Good afternoon, everyone. Thanks so much for joining us. We're going to start letting people in. You are here for our November uh, installation of our ongoing tenant landlord webinars. We've been doing this for a couple years now. So this one is going to be covering the upcoming tenant right to organize that's being put into law starting at the beginning of next year. It's going to be, I think, really great, informative, with a great piece of legislation that's going to be hopefully really, really helpful for lots of folks. So we're going to let folks come in and we'll get started here in a little bit. I'll have a couple of housekeeping things to get through, and then we'll get the show on the road. So we'll just give it another 30 seconds or so. See if anyone else comes to join us. Okay. All right, I haven't seen anyone else come in, so luckily this is being recorded, so it doesn't really, if someone comes in late, they can catch up again. So my name is Rachel. I am here with Homeline. I am a housing attorney and communications coordinator here with Homeline. I'll be kind of running things in the background here, but luckily we are being joined today by two experts on the new right to organize statute that is going to be coming into effect. So we have Juan Luis Rivera Reyes from the Alliance Coalition organizer there, and Margaret Kraplin, who's the president of the Housing Justice Center. So thank you both very much for joining us today. In case you don't know, Homeline, we are a nonprofit here in Minnesota. We help tenants kind of navigate what their rights are under Minnesota tenant landlord law. We've advised probably over 330,000 at this point, since we've been open since 1992. We do offer our services in 4 languages as well as an email option. This is our contact information. Most of the stuff that we do is by phone, but again, we also have email. We offer language lines in English, Somali, Hmong, and Spanish. And so you all know we do have webinars every month, and upcoming next month, we're going to be having folks from the Minnesota Department of Revenue and some other resources talk about updates that are coming in 2025 to the renter's credit. And then in January, we'll have our own policy director and one of our policy attorneys here at Homeline talk about what is going to be part of our agenda for the 2025 legislative session. So you can learn more about those at our website, homelinemn.org. And then just a couple of housekeeping things here. As you probably heard when you came in, this session is being recorded. So if you missed anything or if you want to go back over it, it will be up on our website in a couple of days as soon as we're able to get it kind of off of the cloud. It will also include a PDF version of these slides. If you have questions, love questions, encourage them. Please, please, please ask away. But please use the Q&A function that's at the bottom of your Zoom screen. Don't put them in the chat. I'll be putting lots of information in the chat, and there's going to be a strong likelihood that if you do put your question in the chat, I'm going to miss it. I will feel bad later to have missed it, but we can just get right over that. And if you put your question in the Q&A, I should see it and we should be able to get to it as time allows. We will be applying for CLE credits for this session. We'll send you out that code once we have it. So if you don't know what a CLE credit is, don't worry about it. You probably don't need it. So, but it's for continuing education for lawyers. Um, but all right, that is me. That's my housekeeping. I'm going to turn it over to Margaret and La Louise. Thank you so much.
Yeah, I can get us kicked off, Margaret, and then I'll hand it over to you. But yeah, good afternoon, everyone. Thanks for joining us today. My name is Juan Luis Rivera Reyes. I use he, him pronouns, and I'm a coalition organizer at the Alliance. Kick it off over to Margaret.
Hi, everyone. My name is Margaret Kaplan. I use she, her pronouns, and I am the president of the Housing Justice Center.
We, well, before we dive into kind of the specifics of the policy itself, wanted to take the time to provide some context, some history, kind of what brought us to this moment. Um, As I mentioned, I'm a coalition organizer at the Alliance. I work primarily on our housing coalitions, known as the Equity in Place Coalition and the Housing Justice League. Um, this body of work is really found within the Equity in Place Coalition, and Equity in Place is a coalition of now 20 nonprofits within the metro area, predominantly staffed and led by BIPOC folks, with the issues, with the focus of promoting racial equity at the forefront of housing issues as we are working to achieve housing justice. Um, Together, we are comprised of a variety of different advocates, organizers, legal minds, researchers, and developers in some capacity that have come together and identified um, kind of just what are the shared issues that we're seeing in community as we are trying to organize and advocate with folks in their rental properties. As we kept asking this question amongst each other and kept wrestling and struggling with this, it became very apparent that one of the major barriers to being able to advocate for folks was our ability to organize with them. So this is where the right to organize really emerged, and just a combination of shared experience of our organizers across the metro and tenant leaders, just recognizing that there wasn't any legal protections in the state of Minnesota prior to in order to protect the activities associated with organizing and doing tenant organizing for the tenants that are engaged in those activities. So it wasn't something that was illegal, but also wasn't something that was legally protected. So it kind of was found in this like gray area of protection for these activities sometimes needed to be leaned on other protections that were existing and weren't clear protections for retaliation for activities associated with organizing. So um, we really came together as folks in the ecosystem to identify what are the issues that folks are experiencing on the ground, and how can we begin to alleviate this immediate issue of our inability to organize with folks, or for folks on their own to be able to organize in their own rental communities. Um, and with that, we really took the time to hear the ways and see the ways that folks are already engaging and organizing in their existing properties and in their existing communities, and use those and use those learnings to really tailor the right to organize ordinance. So as we dive into the specifics of the ordinance, you'll start to see the areas where um, the credit can be directly given to the tenant leaders and the folks that were organizing prior to this bill even becoming uh, letters on paper. So um, it's really great to be able to see this work move forward, but then also to give the grace and the gratitude to the tenant leaders who did this work and exposed themselves to this type of advocacy without these legal protections being in place, so that other folks starting January 1st of next year will now have these protections. So wanted to provide some folks some context on how it came to be. Really excited to dive into some more of the specifics, and would love if you want to share any more, Margaret, that I might have missed.
Yeah, so just a couple of things that I think are important context before we jump into kind of the guts of it. Um, the first is that the right to organize didn't exist for most people in most apartments. However, there were some exceptions, and we weren't starting from zero. So, for example, there have been fairly robust protections for people to form resident associations and to organize and to have freedom of expression in manufactured home communities. There are also certain protections that existed for people in different kinds of subsidized buildings, but it varied depending on what kind of building you were living in. So, for example, for people who were in HUD buildings, they had some very robust rights to organize. But for people who were in, for example, maybe a low income housing tax credit building, those same protections didn't exist. And oftentimes, it really created a significant barrier to people addressing very real concerns about health, about safety, about their rights in their rental housing. And so people really felt like they were on their own when they wanted to raise an issue or a concern with their landlord or with the city. The other thing is frequently people did face retaliation when they raised up some of these issues, either with their landlord or with public officials. So, for example, we know of one community where people who were organizing would get strikes on their record that were used against them to try and set up an argument that they should be evicted, so that that was a violation, and if you got a certain number of strikes, then you were putting your housing at risk. Now, it's not that the landlord necessarily could evict that person, that that wouldn't have defenses. However, it created a sense of uncertainty for so many people in their housing, and that was very much creating barriers for people getting sort of what they really deserved. You were paying your rent, you had signed an agreement, and what were you getting in return? Well, what you were supposed to get in return is safe, stable housing that follows certain laws and certain rights. But oftentimes it was really difficult for people to access that without feeling some sort of pushback. And very importantly, one of the things that we've seen in our work with communities, and I know that Juan Luis has seen this in the organizing work that he's done, is that oftentimes it's people with the fewest options and the highest barriers to accessing housing um, who felt the most vulnerable raising up issues. So, very low income households, people with disabilities, people who were undocumented, oftentimes were concerned if you try and get your stove fixed, for example, or you try and work with your neighbors to get issues addressed in your community, that the type of retaliation you could potentially face was very severe and could affect every aspect of your life. And it could put your housing at risk. So that's one of the reasons why I think people connected with this issue so much and so closely was because they really saw what it meant for their own lives and what it meant for their neighbors' lives as well, too. I think next slide. So the one thing I'm gonna kind of point people to is that most of the tenant right to organize language is in a section of the law called 504B.212, tenant right to organize and tenant associations. And one of the very first things it does is it sets up, well, what is a tenant association, right? Um, and what are your rights as a tenant association? So tenants within a rental property now have a right to form a tenant association. And the way that the law is written, it says that they have a right to establish and operate an association for the purpose of addressing issues related to their living environment, which include the terms and conditions of their tenancy, as well as activities related to housing and community development. So it's pretty broad, right? That can be the condition of housing, it can be the treatment of people within that housing. Also, owners of residential rental units and their agents. So it's a pretty broad definition that includes not just the person who owns the building, but everybody who works for them, must allow residential tenants and tenant organizers to conduct activities related to either the establishment of an organization, the organization of it, and the operation of it. And in another part of the law, in the definition section of 504B, it has a definition of what a tenant association is. And a tenant association is a group of tenants from two or more rental units that are owned and operated by the same landlord. So, this is important for a number of reasons. One, it doesn't set a really high threshold for people to say we're forming a tenant association because everybody kind of has to start with where they are. You start somewhere, right? And so you need the protections during the formation as well as during the operation of a tenant association. You'll also notice that it says two or more rental units owned and operated by the same landlord. And that's there for a number of reasons. Sometimes you'll have multiple buildings that are owned by the same landlord where it makes sense for people to work together to address common issues or problems. And this is particularly important for folks who are in single family rentals or scattered site rentals. So really trying to acknowledge that people need this ability to work with each other across a variety of different types of rental housing. Next slide.
Yeah, I can
Um,
jump in here, Margaret. Um, yeah, so as Margaret is naming just kind of some of the parameters, what are some of the reasons for an association? I think folks find themselves in multiple different um, circumstances when they're trying to advocate for, as Margaret mentioned, things as basic as a repair of a utility or in their unit or an amenity in the unit to something more communal, such as like one of the main entrances to the property not being properly secured, right? There's a variety of different spectrums for what folks are looking to organize for. But then there's some specific reasons for why an association can be advantageous in that advocacy. Um, One is really it can serve as a base um, for advocacy for residents to just begin with, in the sense of like it really creates a foundation from moving advocacy from an individual level where it is based on a lot of just different circumstances on folks' ability to or desire to engage in that level individually to really moving that effort to a collective effort where you're joining in solidarity with others who are experiencing a similar situation as you and advocating from that kind of stance. Also serves as a great opportunity for tenants and folks in the neighborhood to kind of coordinate and be able to establish lines of communications with the property owner, the city, and other entities that might have influence in their property. Whether it's the school board, um, property management companies, or so forth. Just serves to have another good foundation of collective folks being able to use their collective voice to advocate a specific entity that folks might be looking to influence. Um, Also serves as a great opportunity for folks to build community amongst their peers. So, as for folks who have rented, sometimes it's not always that you see your neighbors on a regular basis or have the opportunities to front face with them and really create genuine relationships with one another where a tenant association, in addition to the regular meetings and kind of just like the day-to-day operations of it, really moves the conversation for folks in the community from not really knowing each other as well to really intentionally having to to know each other to be out there for each other when times become rough or when times are good to organize for a variety of different things in our community. So really serves as a great um, bench point for folks to really gather and start building the sense of community that we all want for ourselves. Oh, I moved the slide. Here we go back. Thanks. And then it also just serves for a broader base of advocacy for you and your community. So again, we all know that there are situations that are present and are within the confines of the rental property that are the home that we occupy or live in. But then there are other factors within the neighborhood that might also interfere or impact where you live as well. So it also serves as another area for folks to not only organize for better conditions in their property, but also better conditions in the neighborhood, depending if there's other things that are of interest for folks. So it really just serves as a great opportunity for folks to just build power more broadly for whatever area of interest that the community might have that's affecting their ability to truly live there in peace. Now we can go to the next slide.
Great. So under the legislation that was passed, there are a number of different kinds of activities of a resident association that are protected. And what the law says is that the owner or their agents must allow residential tenants and tenant organizers to conduct certain activities, including but not limited to. So, in other words, there are a list of activities, but it's not an exclusive list, right? So if there are other kinds of tenant organizing activities that people want to do, um, those also can't be prohibited. But it does list some things very specifically. The first is distributing information or leaflets in common areas of the residential building, including bulletin or community boards. And this is a question that we've gotten a lot from people like, can I post something on a bulletin board? Well, under the new law, people will be able to. Um, Secondly, distributing information or leaflets to individual units of a residential building. So, in other words, that flyering door to door, doing the door knocking, talking to your neighbors. They can't prohibit you from initiating contact with tenants through mail, telephone, or electronically. So they can't say you can't talk to people, you can't send them a letter, you can't call them. I don't know how people would know if you did, but they cannot, the landlord cannot prohibit that. They can't prevent you from initiating contact with tenants to offer information on tenant organizing, to survey people on interests in tenant associations. So they can't prevent you from making those kinds of informational connections. They can't prevent people from assisting each other and participating in tenant association activities. And they can't prevent people from convening tenant association meetings in a space at the residential building. So if you have a common room or a meeting room, the landlord isn't allowed to prohibit people or interfere with people gathering and meeting in those common spaces. Next slide. Um, but along with those, there are some sort of details, limitations, and restrictions as well. So the first that I'll mention is that a tenant organizer who isn't a residential tenant of the landlord must be accompanied in the residential building by a tenant who resides in the building. This was actually the one issue that that Equity in Place um, had to kind of give a little ground on in the negotiations, as we wanted it to be a little bit wider, but they said no, you have to be accompanied, and they had some specific reasons for that, and it wasn't too much to give up on. Um, Secondly, the landlord doesn't um, isn't required to provide the tenant association or tenant organizers with any information about the tenants. They don't have to provide a mailing address, telephone number, electronic contact information. So they do not have to do that. Um, Another thing that isn't listed in here, but I think it is important to note, is a tenant association using these rights has to adopt some sort of either bylaws or an operating agreement related to how they are going to function and how they're going to work. So that's one of the things as people are coming together, they have to have an agreement of how are they making decisions, how are they running and operating themselves. Um, the tenant association also has to be completely independent of the owners, the managers, and the representatives. And what this means is that um, the landlord and their agents cannot attend meetings unless they are invited by the tenant association to those specific meetings to address specific concerns. So they can't just show up and say, but we're the landlord, so we get to be here. Nope. The law says this is protected because it needs to operate independently. And also, um, the landlord can't pass any unreasonable restrictions on the time, place, or manner of organizing, and organizers are not required to get permission to do organizing activities. So, broadly speaking, um, people have the right to, and this is from the language of the statute, peacefully organize, assemble, canvass, leaflet, or otherwise exercise within the building their right to freedom of expression for tenant organizing purposes. So no advance permission is required. in those protected activities, and they cannot adopt or enforce rules that are unreasonable limits on time, place, and manner of meetings or communications with tenants in the building. So, for example, um, could they have a rule that says you can't do flyering and door knocking at 3 in the morning? Yes, that would be a reasonable rule, and it would be really irritating if somebody did that. However, could they say you can't flyer at 6 p.m.? No, they can't have a blanket prohibition on that. That seems unreasonable, right? So in other words, this is really crafted to allow people uh, to be able to work together in a way that works best for them with limited interference from the landlord, as long as people are operating in a sort of reasonable and non-disruptive manner. Next slide.
Yeah. Within compiling this ordinance, we really wanted to make it clear the retaliation protections in addition to naming out and kind of listing out what Margaret just covered of just like the activities. And really being clear that even through the list of activities associated with organizing, that is not all of them, right? So really important that it includes that other component of not limited to. Um, but with that in mind, right, we wanted to make it very clear within the retaliation component of this ordinance that property managers and property owners wouldn't be able to retaliate against tenants for participating in activities of a tenant association. Um, so within that, 504B usually on ordinances that have some type of financial penalty to it, it's usually $500 per occurrence. We increase that penalty up to $1,000 per occurrence. So each time a property manager or that your rights are being violated in this capacity, you'd be able to submit that form of retaliation in that sense. So that means if one day you get a notice of um, like a strike of what Margaret said before, because the day before or the evening before you went out door knocking in your neighbor or around your property, that could be considered retaliation because of the activities that you were doing of door knocking and sharing information with your neighbors. So that could be classified as a retaliation because you were engaging in activities associated with a tenant association. So we really wanted to make it clear in listing and defining what those activities were, that these were activities that folks are already engaging in today's ecosystem, and then also creating the space for other activities that might emerge in folks' advocacy to also be protected from retaliation. As we know, that's the biggest barrier for folks being able to feel confident in engaging in their own advocacy is just the fear of retaliation and the ability that retaliation can have in displacing them um, temporarily or in a long-term setting. So
So, one of the things that is the way that this is structured is it outlines two things. One, what is an example? What are the retaliatory actions? So, what are people, sort of a landlord, not allowed to do? And then, what are the protected activities? So, the things that sort of trigger your retaliation protections. So I'm going to talk a little bit about retaliatory actions. What does retaliation look like? And it doesn't look like just one thing. For example, um, i- under the the statute, it says a landlord may not increase rent, decrease services, alter an existing rental agreement, file a legal action against a tenant. This is an important one. Contact federal or state law enforcement related to a tenant's immigration status, or seek to recover possession as a form of retaliation, and they can't threaten any such action in whole or in part in retaliation, right? So they don't have to have made that call or have filed that eviction action. The threat of doing so, if it is in whole or in part retaliatory, is prohibited under the statute. Next slide. And go ahead.
Perfect. Yeah, as part of this, right, so like I've been retaliated against, what do I do now? So really what we wanted to make clear for folks as folks read through the ordinance is this 90-day protections period. So within the first 90 days, let's say you're retaliated on Monday, Tuesday, or that Monday later in the day, you submit that notice of retaliation. You, since the day of the retaliation, would have 90 days of protected activity, where the burden of proof, if the situation, if the case went to court and you're in front of a housing attorney or housing judge, the situation that you'd be finding yourself is in those 90 days, the first 90 days, the burden of proof for the retaliation having occurred is on the landlord to be able to demonstrate, or the property manager to be able to demonstrate that they did not engage in those such activities. After that 90 days, oh, go ahead, Margaret.
I was just going to say, I'm just going to clarify something, and that is sort of when that 90 days starts. Because the 90 days starts when you do one of the protected activities, right? So, for example, I think a really good example is, say, there's a repair issue in your apartment, right? And you make a report to, or you request a repair of your landlord. You say, hey, landlords, my refrigerator isn't working, and I would like this repaired. All right, so you've done something that is a protected activity for retaliation. Within the 90 days after you did that, then the burden of proof is on the landlord, if they take an action against you, to prove that it was not in whole or in part retaliatory, right? And every time you do a protected activity, you kind of restart that 90-day clock in terms of the burden of proof. You can be like, well, okay, like I contacted the city and nothing happened. And then I contacted the city again. And then 89 days later, they tried to increase my rent, right? The burden of proof is on them to show that that increase in your rent wasn't a retaliatory action, right? And then after the 90 days, the burden shifts back. So you can still raise retaliation. It's just that you have to, it is your burden as a tenant to prove that it's retaliatory rather than the landlord's duty or their burden to prove that it wasn't retaliatory.
I think that part is critical too, and just expanding on that of like why that shift is important is like that first 90-day window, right? It's already a monumental effort as a tenant to do this advocacy on your own, as it is. So to have that first 90 days where the burden of proof really is on these management companies or these property owners to demonstrate in part or in full, that the actions that were taken weren't retaliatory in a lot of cases, that this is hard to do, especially with just like, maybe I should be a little more PC about my language here. There's a variety of different like factors that are present, and folks being able to tracking of their actions, or a variety of different things that burden of proof really being on the other party for the first 90 days is advantageous for the tenants to be able to, on their part, continue to document, continue to track, continue to be on top of the ball, and being able to demonstrate a timeline and the protection of the activities that they've done to be able to effectively demonstrate where the retaliation happened, how it happened, so that if the other party does fail to be able to prove in part or full that the activities were in retaliation, you have that proof as well to be able to demonstrate counter.
Yeah, and one thing I'd also point out as well too, and thank you, Rachel, for popping some of the other kind of statutes in the chat because I think it's really important. And that is, even though this section of the law is under tenant right to organize in tenant associations, the list of activities that you can take that would be considered to sort of like trigger that 90 days are much broader than that. So for example, they can't take one of those actions or threaten those actions after a tenant reports a code violation to a government agency, elected official, other government official responsible for enforcement of building, housing, health, and safety codes, reporting a building, housing, health, or safety code violation or a violation of this chapter to a community organization or the news media, seeking assistance from a community organization or others, including media and news organizations for assistance with code violations or violations of 504B, requesting repairs to the building, joining a tenant association or other association, testifying in court or administrative proceedings. So any of those types of activities are covered by this retaliation provision of the tenant right to organize. And one of the things that Rachel pointed out is that there have been laws prohibiting retaliation for a long time, right? But they are operating principally under the defenses to eviction. So in other words, you can raise retaliation as a defense to your landlord trying to force you out, if that is the case. And it can even be an affirmative defense. Thank you, Homeline, for a great Minnesota Supreme Court case that established that it can be an affirmative defense. But the difference here is that in this instance, tenants can like proactively raise this issue of retaliation as well too. Next slide. So what happens if somebody violates this law? What happens if somebody tries to retaliate against you? Well, there is a penalty section in this part of 504B that says if a landlord, an agent, or other person acting under the landlord's direction or control unlawfully and in bad faith violates this section, law, the tenant may recover from the landlord up to $1,000 per occurrence and reasonable attorney's fees. Now, there are a few kind of keywords in here that are important. One is that it has to be, the conduct has to be unlawful. Well, that is pretty clear, right, under this ordinance, and also in bad faith. So in other words, if somebody accidentally does something or unknowingly does something, that's probably not in bad faith. So that's going to be like a harder activity to challenge. But also, a lot of time people know what they're doing, right? And it is hard to like not know that you're filing an eviction against someone or not know that you're reducing somebody's services. So that is really important. The other thing is, this is sort of like a statutory fee for doing this. But like a lot of things in tenant landlord law, sometimes it can be very tricky to enforce this. So it would require somebody taking an action against the landlord in order to recover this. Typically speaking, it would be through filing some form of lawsuit. And that's one of the reasons why it was really important for the Equity in Place group to include both a dollar amount, because we know retaliation happens all the time and there really aren't consequences to it. So we wanted there to be actual consequences to violating people's rights. And also it includes reasonable attorney's fees, because that way folks are, in theory, going to be able to bring these kinds of cases without sort of expending a lot of effort, but not being able to pay for the effort it takes. Like a lot of other tenant landlord laws as well too, because this is under 504B. Um, it also can be, it is under the umbrella of consumer protection laws that very broadly are under the jurisdiction of the Attorney General's office as well too. So, so in terms of like being able to enforce it, it's really going to be private enforcement, but it can also be through the Attorney General's office. And our hope is that once people realize these rights exist, like people mostly want to do the right thing, right? And so as landlords and property owners become more and more aware that these rights exist, that they won't want to do it, right? They want things to work right. They want to be following the law, and so hopefully there won't have to be a lot of activity to enforce it. But then if there is, this creates some mechanisms to do so.
That was our presentation.
I'm coming back. So many buttons to push. Sorry. Um, I was just trying to get all the flurry of links and things that you all mentioned the last 5 minutes. So thank you for that. And thank you both very much for the presentation bits. We do have several questions that have come up, both between pre-submitted questions and ones that have come in during the presentation. Again, for those who are here with us, please, if you have questions that have come up that you want answered, please put them in the Q&A so that we can go through them. You know, again, the Q&A is the best place to put your questions in. I'm going to start with a couple of the pre-submitted questions just because that's one of the perks of having a pre-submitted question is you get to go first. Um, so we had a lot of tenants and some service providers asking about uh, lots of things. So I'm going to specifically try to focus on the ones that are about today's presentation first. We did have some that were about other landlord tenant related things, so that I'm happy to go over that as well if we have time later on. But I'm going to focus on the right to organize stuff first. Okay, so the first one I've got here, um, Izzy, I believe, is a tenant, and they're wondering, are there any examples that you can give of tenant unions that, and kind of forming ones, any good examples of those associations that already exist that might be a good guideline for folks who might be going into this?
Yeah, I think there's some really great work being led on for tenant union wise and Duluth with the Duluth Tenant Union. I think they're doing a lot of great work up there. Um, I think that'd be a really great resource for folks to reach out to and try to connect to learn more about the tenant union side of things. So I think that's a large, more comprehensive effort to cover renters as a whole in Duluth, where I think an association would be a little bit more, at least from its beginning, would start more confined within your initial rental property. Um, I think examples we've seen of that. Really the successful ones we've seen of that are in manufactured housing where this protections have existed for a decade or more now, where folks have been able to really establish resident associations with bylaws that are clear, and how they're going to operate in the ways that they would like to do their advocacy generally. I think those would be great options to look into in the what's it, the resource that was shared from the tenant organizing guide in manufactured housing. I know Housing Justice Center also, in conjunction with Homeline and other advocates, published the Minnesota, um, what is it called, Margaret? The organizing guide, renters
Is
organizing
it the
guide.
Minnesota Renters Guide to Tenant Organizing?
Yes,
Yes.
yes, the Minnesota,
Cool.
yes, which is
Th-
really comprehensive and has
Thank
a
you.
lot of information.
I will
Yeah.
link to that right now.
Yeah, and there are a lot of examples of people organizing like specifically within a building to address. A lot of the times it can be health and safety issues like we've been asking, we're not getting our repairs, we're going to work together and push for repairs. Um, yes, IX has done some great work in both the the former Friends property, so like what became Sky Without Limits Cooperative, they also did some really great organizing in the properties that were owned by um, uh, Havenbrook, which became Predium, which became someone else. But those were like scattered site rentals where people were having very serious issues with health and safety and repairs. I think some other really good examples are there are some folks at Homeline who've been working with folks in some of the Dominion properties, for example, trying to address a range of different issues. And there was some great organizing done in Minneapolis with like the Madison Apartments, Karina Bollinger and her neighbors trying to really, honestly, part of what they did was prevent their building from getting torn down, right? And getting pushed out and relocated. So it's really about people coming together and figuring out what is most important to you, what do you care about, and then how do you work together in order to address those issues and concerns in your own community. There's a lot of really powerful stuff happening though on the hyper local level.
Yeah. And I think one thing that's important to call out, just because it is part of the definition and it might be something that folks don't necessarily think about when they're starting to organize together, is that there is, to be considered a tenant association, at least under the law, it does need to have some sort of more organized formal structure, in that there needs to be some sort of bylaws or organizing statement where it's clear that, you know, folks have put in some thought about like how they want themselves to be organized. Great. So perfect. Thank you all so much. And I just put a whole bunch of links in the chat as well. Um, so then the next question we have got, if I can find that page again. Um, so Ronald is a tenant, and I think you mentioned, kind of touched on this a little bit, but I want to make it very clear for folks. Ronald would like to know, does this law cover public subsidized housing?
So it doesn't not cover public subsidized housing. However, depending on the kind of public subsidized housing you're in, you may have even stronger rights under some of the rules from, for example, HUD. So if you are in, here's a good example, project-based Section 8 housing, there are very robust requirements and rights for forming a tenant association in those buildings. Where if you're in, for example, subsidized like a tax credit building, there wasn't anything that protected the right to organize and be free from retaliation in the same way. So think about this as sort of establishing a floor for a lot of different people who are in rental housing, because you've got that definition. If you are a residential, if it is a residential rental unit, is big and broad, but you may, under whatever program you're connected to or a part of, have a set of additional rights on top of that.
And I posted this earlier, but I posted again. I found the HUD Handbook on Resident Rights and Responsibilities. So it's much broader than what we were just talking about here, but there's a good, if you want to do a real deep dive. All right. So Tina and I apologize if I am mispronouncing that. Sharasi or Charisse. They're both tenants, and kind of just to go over again, both of them are really like, how do I form a tenant rights group in my area? How do I make sure that I'm recognized and legitimate? So going through and following those tenant organizations, associations, making sure that you've got your uh, bylaws or organizational statements or whatever in place. But there's some really great resources that we posted here. Um, so then, well, Jax has an interesting question. I don't know the answer to this at all. But is there a difference between a like a tenants union and a tenant like organizing association? Is is there any actual difference, or is it just kind of the same potato potato?
Uh, I don't know, Wendy, what your thought is. Go ahead.
The way I've interpreted the difference between a union and an association is like a union is more comprehensive in scope, where associations could be more confined geographically. So association could be a neighborhood association, it could be a property association, it could be a portfolio association, where I think a union comprehensively would cover the neighborhood, individual properties, and kind of like portfolios within a specific city that a union is being done in, is the way I've interpreted that. But I think layman's language terms, they're very interchangeable and the ways that folks use it.
I'd
That's
agree.
good.
I think people largely use them pretty interchangeably. The one difference is that now there is a definition in Minnesota law of a tenant association. So a group of tenants of two or more rental units who are owned and operated by the same landlord who form or maintain an organization, whether incorporated or unincorporated, to improve housing conditions, amenities, community life, or the contractual position of the member tenants. So, in that Minnesota definition, now you've got, you know, you're living in a property owned by the same landlord as the other people in your tenant association, where a tenants union can be, and a lot of times tenants unions are like citywide or really much broader than that, and focused not just on like the conditions in one building, but also like building the power of tenants in general, to make sure that their issues and concerns are being paid attention to, a lot of times like on a city level.
Mhm.
Mhm. And I know the definition we have here for a tenant association is about all under by the same owner versus unions can be kind of across owners and areas, right? Okay. I'm pulling that off of a little bit of what Lucid has put in. Lucid is one of an organizer that we know who has kindly dropped in a definition for us as well. Um, so another question, David is asking, they're a tenant, and I think that this is a might be a good time to talk about what happens if you either don't have bylaws or your bylaws are really like they're on a napkin that just says, two of us are getting together to, for, have Ron's responsibility is bringing coffee and my responsibility is bringing donuts every other Friday. Like, is that enough to form a bylaw? And what happens if, like, you don't or you don't have bylaws at all? And so what can a landlord do in that case, or if, you're organizing?
Yeah. So, the bar in the uh in the statute is pretty low in terms of like formation and bylaws. So you have to adopt bylaws or an operating agreement related to the internal governance of the tenant association. So that actually could be, we put something on a napkin, right?
Sure.
I think where you end up, you need to have something. And if you don't have something, that's one of the things your tenant association could do is come up with something, right? And if you ever need to use this, right? If you're trying to say flyer in your building and you're getting pushback and you're like, no, this is protected right, and we are forming a tenant association, and they say, no, you're not, right? And it ever comes to sort of a conflicting in court, for example. You want something that you could point to that looks more than I will bring donuts. But you can make a case that that is all you need is the I will bring donuts statement. The thing I would say is think about it less in the context of like what you need to defend your tenant association if you go to court, and more, do you have a sense of how people are going to be agreeing to work together? Because these operating agreements or bylaws aren't really designed to like prove you're real. They're designed to make sure that you've got a clear understanding of how you're going to be working with each other and how you're going to be making decisions together. So think about it less as sort of like these are legal questions and more as these are really organizing questions, and you can't, it's hard to organize with your neighbors if you don't really have a clear understanding of how you're going to be working together and how you're going to be organizing and what your process is for making decisions.
Sure. All right. So Lisa would like to know, how do we get landlords to understand and abide by the new and upcoming statutes and related requirements?
Correct me if I'm wrong here, Margaret. But I believe in the state of Minnesota, it is their responsibility as someone providing a service to be up to date with current statutes. Does that always happen? No. So I think part of it is really just like advocacy as community as well. I think with the establishment of this law, it is very much like the due diligence of property managers and landlords to ensure that they're up to date with Minnesota statutes in this realm. But I think it's also just as important for folks in community as you're learning about these rights to also be informed to the best of your abilities of what these rights are. So if these situations do arise and the property manager or owner is unaware of these new existing statutes, you are able to articulate it. And again, the way that it's set, if they violate it, they're the ones that ultimately have to prove the burden of proof, and it's not, and again, correct me here, Margaret, I'm not the attorney here, but from my understanding, it's not a sound legal argument for them to go in court and argue that they were unaware of existing statute because it is their due diligence to inform themselves of existing statutes.
Yes, there, that's right. I mean, I think here are a couple ideas that I have. And I think it is in all of our best interest to have as many people know about these rights as possible, right? Because you don't want every time you try and organize to have to be a battle, and you don't want to kind of feel like you have to defend against things that are happening to you as a tenant that could be retaliatory, right? These are important rights, and so it's in everybody's best interest for them to be honored. A couple of things. One, webinars like this are a really important tool. The second is using media, both sort of like the newspaper. So there have been some articles that have come out about the right to organize, both during the legislative campaign that Equity in Place was working on, as well as after the fact. But there are a lot of places around the state where, we just need to get the word out to more and more people about it. The other is, hey, you have a right to organize, and that includes the right to put things up on bulletin boards. And so one of the things that I think would be helpful that I'm putting in my to-do list is creating like a one-pager about the right to organize that people can put on bulletin boards, because that is a protected activity, and it's important for people to know that, right? So it is, on the one hand, it is a landlord's responsibility to know the law. And on the other hand, it's also, I think, in all of our best interest to make sure that we're getting the word out. Because the other thing too is tenants living in buildings in, counties and communities across the state, if they don't know they have these rights, then the rights aren't real and they don't exist for them. And these are important rights. So we really want to make sure that everybody knows, that every tenant knows they have these rights, and every landlord knows that tenants have these rights.
Yeah, and I like to point out as well, like as part when this was being discussed and passed through the legislature last year, Equity in Place and y'all did a really great job of making sure that both landlords and tenants, organizations knew that this exists. And so it's not like it was being done cloak and dagger behind closed doors and all of a sudden the right to organize is going to burst out on the scene on to answer someone else's question, January 1st is when this is all going to be effective in law. So there wasn't a sneak, no one was being sneaky about it.
No, in fact, we met with the multi-housing association
Mhm.
and, had a discussion about what it was and what it looked like, and uh, so nobody is surprised by this, and they definitely came out to testify against it multiple times.
So, like, yeah. So folks will, as with many other laws, it'll permeate its way into our existence. All right. Juan Luis, did you have anything you wanted to add or? Okay.
No.
I just, all right. So, Janet, we kind of covered the, communications that must be allowed now. Those are all kind of listed there. Um, Rate is an interesting question, and I just want to make sure that it's clear, like who this actually specifically covers. So, Reed is wondering if they can organize, and I'm assuming be protected under this new law, at a U of M owned housing co-op.
Um, well, um, you should be able to if you are falling under the definition of a residential tenant of a residential building, right? So a residential tenant is a person who occupies a dwelling in a residential building under a lease or contract, whether oral or written, that requires payment of money in exchange for services. All other regular occupants of the dwelling unit and the resident of a manufactured home community. And then a residential building is a building that's used in whole or part as a dwelling, including single, multifamily structures containing both, and includes manufactured home communities or an unoccupied building that was previously used as a dwelling, right? So if you live in a U of M owns cooperative building and you have a lease to live in that building and you are paying money to live in that building, then you are a residential tenant, and that is a residential dwelling unit. So I think you could very easily argue that this does protect organizing in your building because there isn't an exception that's out
Mhm.
there for co-ops.
Now, if Reed is an owner, like a part owner of the co-op, is that different? Same, you think?
Um,
I'm going to point out that these are new laws, and so we say this a lot coming through all of our webinars, especially on new laws, is like a lot of these are things that we don't necessarily know all the answers to yet because they haven't been through courts and they haven't actually like hit the real world. And so we're making our best
yes,
educated guesses here.
best educated guess. I mean, I'm assuming, there's you could probably argue, but I think that especially I'm assuming those are limited equity co-ops, right? And so people are shareholders, so they don't own a unit, they own a share of the building that is owned by the cooperative.
Mhm.
So I think you could argue that it you would still fall under the definition of a residential tenant and it would still fall under the definition of a residential building. It's probably gonna be I mean, like a little murky as well too. The other thing that's interesting about cooperatives is depending on how they're formed as well, is your do you have a cooperative association that has primary responsibility for all of these things that you're talking about? Or is it really kind of a little bit more of like you have your association, but the building is largely operating without paying attention to what the concerns are of the association. So, there might be more than one way to address the issues in a cooperative than you might see in sort of we're just renters in an apartment building completely owned by somebody else. But that is a murky one and really interesting. And you probably can do something, but it might be the path might be a little bit different.
Mhm. Yeah, as you pointed out before, like it's not that organizing activities were prohibited before, it's just that they weren't necessarily protected explicitly under the law. All right, that is the end of our pre-submitted questions. Well done. So now we have had several that have come through on the Q&A. We've answered some of them already, so we'll go through some of the more um, unique ones that we haven't necessarily covered yet. But Alyssa asked this like right off the bat, and I just want to kind of go over again a little bit. Are tenants allowed to go and essentially talk to other tenants in other properties, whether it's in your own building or whether it's on another property owned by the same landlord?
So, yes, you have a right to talk to other tenants in your building. You have a right to talk to other people in other buildings, though you may need to be, if you're talking to people in other buildings, you may need to be accompanied by somebody who resides in that building.
Hmm.
Yeah, I would agree that that'd probably be the biggest sticking point in that is the need to be accompanied by another resident of the other building as well. But the concerns and especially to the example of being able to ask specific questions around health and safety in relation to the dwelling would fall under the protected activities. It was just that part of like you would need to be accompanied by another resident.
And it's a key, a clutch part of that. Okay. Um, Reed, we just answered one of your pre-submitted questions. We're going to come back to you in a second. So Monique, you had asked specifically about when these were going to be in effect, but specifically as well into the retaliation laws. So we kind of talked a little bit about how retaliation as a concept existed in tenant landlord law already, but it wasn't necessarily, it is slightly different in this context. So um, retaliation laws are already in effect here, but retaliation specific for these activities are not going to be, it's not going to be a defense to anything until after next January. Um, the other thing I wanted to point out that I found out this morning when I was doing a bunch of stuff for this is that the reviser has done a thing that I wish they didn't do. So the reviser is the organization, for those of you who don't know, that puts out the statutes, all the links that I've been putting out on our chat of what, the actual statutory language into these statutes comes from the reviser's office. And even though a lot of these laws are not actually in effect until January 1st of 2025, they have they're very well organized and are well ahead of the game, but they've already posted them to the reviser's website, meaning that if you went and looked up the law right now, it would confusingly look like it's on the books right now, like it's actually in effect right now. And it's not. But there's not really any indication that the timeline exists. So just be aware that these things, while it does show on the reviser's website when you're going to, so if you like were Googling right to organize in Minnesota, this would pop up. But it's not actually in effect until January 1st. And a lot of the new laws are not in effect until January 1st, not just this one. So fun little thing that I found this morning that I'm less than enthusiastic about. So sorry, completely sidetracked that. So Ian, sorry, you've written a paragraph for us, so I'm reading here. So Ian has got a question about retaliation, it looks like. So um, yeah, they're saying that they, obviously you can't anticipate in what ways landlords are going to attempt to justify actions within the 90-day period. But is there a benchmark that you believe there would need to meet to be considered proof? So like bringing a rent increase in property tax instead of organized activities. So basically, what does a landlord need to be able to show to be able to rebut this defense?
That is an awfully good question, and until they actually try and do it, it's hard to say what they're gonna come up with. I think one thing that helps though is that the language says in whole or in part. So even if they have another reason for doing things, if that activity happens, if it's within 90 days of something that a tenant did that's a protected activity, I would say that that bar is honestly pretty high, right? Like, I made a complaint about needing my refrigerator fixed, and then a month later, my rent got increased. And the reason I'm saying it's getting increased because my property taxes went up. Well, but is that entirely why? Did it happen to other people as well too? Like, you can kinda look at the circumstances surrounding it and go like, "Do you usually increase the rent at this time of year? What happened to other people who maybe didn't complain? What has been the pattern in the past?" But I don't think that we've really got until this kinda goes through, the court system and get some interpretation. I don't know that there's anything that's like really specific about like this is how much they have to prove up, right? They just need to sort of rebut a presumption. I know that is a
Hmm.
really unspecific answer.
Hmm. It's a really great question. I think to expand on this, like what comes to my mind as well is like the importance for tenants and tenant organizers to make sure that we're keeping a timeline of all the actions that we're doing, right? So having a clear, having a clear timeline of all the activities you've done, so that as this arises and as these challenges in courts happen or don't, folks are able to also articulate very clearly a timeline of activities associated with the advocacy that they've been doing, and also have something that could refute a timeline that is presented from the other party as well.
Nice. Yeah. Keep everything in writing. Love it. Um, okay. So Claire, I'm gonna paraphrase your question a little bit. But the right to be able to post things on bulletin boards. The landlord can't negate that, say, like a resident handbook, right? The landlord can't say, well, you can't post anything on bulletin boards and have that negate the right to organize protections, correct?
Correct.
Okay. So even if your resident handbook says that it's prohibited, after January 1st, it is not prohibited.
Yeah. And I mean, and I would say think about this as this is for resident organizing for non-commercial purposes. So
Sure.
for example, if they're like, you know, don't try and sell Amway on your bulletin board, or it does Amway still exist? Anyway, don't try and like sell stuff on your bulletin board. Like they can have rules against sort of like commercial communications and stuff like that, or not. Um but
Yeah.
apparently Amway is still kicking. But they can't prevent you from doing things that are associated with
Mhm.
the resident association, people's rights, your right to organize.
That's a really good clarification that it's not just anything to be posted. It has to be specific. Um, all right. Um, uh, David is wondering if there's a template or anything about memorandum of agreement or bylaws or anything like that. And I'm not aware of any templates. We kind of gave some links to some resources that you can use, but they are generally pretty specific to your organization.
Yeah, are there any um is there anything in the tenant organizing handbook like a sort of sample?
I don't know if there's one in the current iteration, but I do know when All Parks Alliance for Change was still around, we used to have a sample bylaw that we used to hand out to folks for manufactured housing that was just like very straightforward of like these are what you can populate it with. And it wasn't something that folks needed to populate every section was, but every section that was laid out, but more was just like a template of a guideline of how folks wanted to customize or reduce or expand upon. But I don't know where that went since the shifting.
Yeah, and the Minnesota Renters Guide to Tenant Organizing is 76 pages long. So um, I haven't been able to read all of it yet. And but I think that's a good place to go.
I will say this is a great flag, though, as we are at Equity in Place, but then other advocates in this realm as we are preparing for this legislation to be live. What are the tools that community is identifying, knowing that there's desire for us to have a general template that can be applied universally as much as we can for folks to use is definitely something that we will look to work on.
Fabulous. Okay. Um, Westerly has some interesting landlords who are saying that since they are located in New York State, they keep insisting that Minnesota law doesn't apply to them. Um, so basically, the general question, like that's a very specific situation, right? But the general is, who does this law apply to?
Why, it applies to all people, landlords who own or operate properties in the state of Minnesota, right? So you don't get to choose your laws by incorporating somewhere else. Tenant landlord law in Minnesota, like manufactured home community, like whatever, applies. So it doesn't matter where your landlord is, and it doesn't matter who they are or how, how they're incorporated or whatever. If they are a landlord and they are owning and operating, or one of their agents is operating a residential rental property and you're a residential tenant, then this does apply in your property.
Yep. Thank you for sharing that, Westerly. That makes me giggle a little bit. I'm sure it's really frustrating to live through it, but at the same time, just Lordy, here's something new every day. Um, uh, for HUD buildings, are there any like cross building associations or anything like that, or network of tenant associations for HUD buildings?
Yeah, so there are a couple. So there is so there was a national organization, the National Association of HUD Tenants, that I believe still exists in certain forms. There is also a network called Lofty, that is HUD tenants and LIHTC tenants, and it's a national organization of people trying to figure out like how do you enhance, have both understanding of rights and then enhance the rights that people have nationally as well too. I'd say like Nat, if you're in a HUD building, there are a lot of like really good resources that exists on their website, and um, they really did advocate along with all kinds of folks in states all over the country for uh, the tenant rights that exists in HUD buildings as well too.
Could you drop links for those that I couldn't find? All right. Thank you. Um, all right. So Reagan is wondering, will this law always be have to be a defense to something like an eviction, or can it tenants pursue support through other pathways?
Yeah. So this retaliation law is not designed as defense to eviction. It can be used proactively. Right. So unlike the other retaliation law, like the general retaliation law in overall 504B, that really talks about it specifically in the defenses to eviction, this does allow people to proactively file a claim against their landlord for monetary relief and attorney's fees, which is one of the reasons why we like equity in place was so clear that they wanted that in here because there needed to be consequences for violating.
Fabulous. Thank you. Uh, Janet had a follow-up about the bulletin boards. And this is an interesting one. What if the bulletin boards are locked, like they're behind glass doors or something? Does management have to give access to them? Asking great questions here today, folks.
I don't know the answer to that.
Yeah.
I would argue yes, um, and could argue yes, and someone could argue no, but I think, I think it's the same as like they have to allow you to use common spaces. It says pretty explicitly that you're allowed to post things on bulletin boards, so they can't prohibit it.
Mm-hmm. All right. Um, So then, ooh, I think we have someone who has been through some of our recent new law changes here, because they're asking to confirm, will these laws be effective 1/1 or just leases that are entered into on or after 1/1?
Effective 1/1.
Yep. So it doesn't matter when you entered into your lease, if it was 20 years ago or, February 1st of next year. It's effective. Fabulous. And um, So this is going to be a more legal defense question. But do folks have any thoughts on how to avoid relevance objections to evidence of retaliation in regards to facts related to other tenants, such as showing that the tenants did not have that same rent increase if they're going about saying that this is a retaliatory action? So this is for those who may not be having to like raise these defenses, this is a very legal specific question for like a courtroom defense.
I don't really have a good answer to that, unfortunately. I'd have to sort of plot it through. I mean, since I mean it's kind of an interesting situation, right? Since let's assume that you're taking this action within the first 90 days, and then the sort of the burden on them is to prove um that it's
Not.
not retaliatory. And so I think in part it would depend on what kind of evidence they would be trying to bring to prove that for their proof that it's not retaliatory. And then, I mean, I would argue that you would need to be able to provide that you would overcome that relevance argument by saying that you need the information about how similarly situated people in the building are being treated in order to like rebut the proof that they're providing that it isn't retaliatory. But I'm going to admit here and now that I have not fully thought through that particular argument. Um, and would
Fair.
love any other attorney on the call to to opine.
I mean, I think, what she said is like, even if they tried to argue relevance, if it's within the 90 days, the presumption that the court is going to be working under is that retaliation is there, that this is retaliation, that the landlord has the burden to show that it's not. And that's the kind of the point of the courtroom, is the argument back and forth, and ultimately it's going to be up to the judge to decide if something is relevant or not, or even if something is persuasive or not. So I think a lot of it's going to depend on what judge you get. Cool. All right. Um, all right, one more from Reed, who wanted to know, um, is, and this isn't necessarily, I think, for tenant organizing, but would this protect other door knocking activities that they might be doing for non, say resident related concerns?
So that is a really good question. And I think that in some ways there is a little bit of ambiguity written into the statute. Tell you where it is under 504B.212, um, uh, under F. It says no landlord shall prohibit or adopt any rule prohibiting residential tenants or non-residential tenant organizers from peacefully, and then it has a long list of things. So you have to be a tenant organizer under this, either a residential or a non-residential tenant organizer. And then it tells you sort of like what kinds of activities are protected. But it doesn't necessarily say that everything has to like explicitly just be um about that building, as long as it's for tenant organizing purposes, right? So if you're a tenant organizer and you're organizing tenants, you can be organizing them about something that isn't sort of like specifically dead on a tenant landlord thing in that building, and I think that you could probably argue that you're okay under, this right to freedom of expression. But it's not as, like, blanket and broad as that right in, for example, manufactured home communities, where anybody, for any reason, as long as it's for non-commercial purposes, has a right to freedom of expression in the community. The other thing that is protected activity is if you're, campaigning as well too. So if you're running for elected office, for example, you have certain rights to knock on people's doors and things like that, as long as you're accompanied by someone. So I think it depends on the circumstances, and you could try and argue it if you wanted to.
Perfect. Great, great answers. Also, so we have 3 minutes left and we have managed to clear the questions off the board. So well done. Round of applause for that. That was a lot of information and, brain wheels and cogs going. So thank you so much for taking on all those hypotheticals. I appreciate it and sharing just the vast pool of information and knowledge that you all have. I have put up our information for Homeline, for our hotline and things like that. You've got questions, you can always feel free. If you've got specific questions about your specific situation, feel free to reach out to us. You will have, leave a message and we'll do our best to either answer as we can or direct you to resources that might be better for you. Thank you all so much for joining us today. Again, this will be recorded and put up on our website as we're able with the PDF version of these slides. So thank you all again. Have a wonderful rest of your day and take care, y'all. See you again soon. Bye.
Thank you.
Bye.
Why won't you end?